Hello and good morning, everyone, to this Saturday morning's webinar with Wong Partnership. We are talking about medical, legal, and compliance series. In part of our medical, legal, and compliance series, riding the wave of medical liability with Wong Partnership. Today, we welcome our panelists. First off, we have Melanie Ho. Melanie Ho is the Deputy Head of the Specialist and Private Clinic Dispute Practice. She advised statutory boards and major players in the healthcare and pharmaceutical industry. She was appointed to the Appeals Board of the Dubai Healthcare City, which hears cases on medical and professional misconduct of healthcare professionals. Melanie has been recognized as a highly regarded legal practitioner in the area of life sciences and having been selected by her peers in the best lawyer for her work in litigation and medical malpractice litigation. Melanie, good morning. Welcome to the webinar. Hi, good morning. Good morning.
Hi.
And alongside Melanie, we have Chan Manping. Manping is a partner in the Specialist and Private Client Dispute Practice. She specializes in medical and healthcare matters. She regularly advises on medical negligence claims involving hospitals and medical practitioners. She's a prosecuting counsel for the Singapore Medical Council and Singapore Dental Council, appearing before disciplinary tribunals as well as the Court of Three Judges. Her main practice areas include civil and commercial litigation that includes dispute relating to companies, shareholders, and employment contracts. Manping, welcome. Good morning.
Thank you. Good morning, everybody.
And of course, as before, seeing through the entire thing is Mr. Alvin Lim. Alvin, good morning as well.
Good morning.
Okay, so today's webinar will be presented by Wong Partnership. So I will hand the speaking over to Alvin, and we can get started. Alvin, if the stage is yours.
Good morning, everyone. Thank you for joining us at this webinar. I hope that as we enter into phase 2, this will be an easier period for everyone to move around. So this morning, we're talking about riding the wave of medical liability. This is an interesting topic. I think many issues have come out in the newspapers recently. So our two speakers today, Melanie and Manping, will hope to shed a bit more light on these issues and how we can address these topics in this current day and age. So I'll hand over the time to Melanie.
Hi, everyone. Good morning. Dragging you away from the election hustings. Today, we are talking about some of the new developments. We will go quite specifically into the cases that we have seen hit the media, especially ones that were convicted below and then somehow overturned in the Court of Three Judges. I think those have caused a lot of interest and perhaps disquiet amongst the doctors who had to go through that unfortunate process, only to be vindicated at the end of the day in our highest court. So we want to look at that, and just to let you know, at any point in time, if you have any questions, there is a Q&A format that you can ask the questions, and we will pick it up as and when it becomes relevant to the points that we are talking about, so that there's a greater flow to our conversation this morning. So please send in questions that you might be interested or controversial matters which have caught your eye in recent years. Now, let me move quickly into some statistics. I think when I saw and refreshed myself the numbers this morning, just to let the doctors know, in 2018, we're looking at your annual report for the doctors. It is published every year, and so far we have retrieved the 2018 one. We have about 400 over complaints received. All right, and that is startling. I mean, Manping and I have been doing this for the last 20 years of our practice. And in the good old days, I suppose, we're looking at double digit and certainly in the very, very low 3 digits. So I would say in the last 20 years, it has quadrupled in numbers. I think that has, like I said, caused a lot of disquiet and concern by medical practitioners, and we hope to be able to arm you with some live voice so that and safety tips so that you can avoid these sort of complaints, not just getting through the complaints themselves. How do you avoid even having complaints made against you? There has been a recent task force that was formed, I think after some prosecution cases that was led, as well as the Montgomery civil case regarding informed consent. They are quite intertwined, and the Ministry of Health had formed a work group in 2019 to review the taking of informed consent. We will talk briefly about how one kind of intertwines with the other. The question of standard of practice set by our courts versus the professional standards determined by the Singapore Medical Council or the Singapore Dental Council. So if you have any questions on that, we're happy to speak about it. I have personally been asked many questions relating to that, especially entities who own several clinics and they want to set some sort of protocol, some sort of knowledge management for their doctors. Let's move on to the complaint process. I think most practitioners are quite aware of this, no less because there has been an unfortunate number that has hit the papers regarding SMC cases. So what I want to highlight is two things. If you can see the slide for those, I will read for those who can't. There's a referral to Interim Orders Committee as part of the process of the Complaints Committee. There is also in the blue the option for mediation. I think this morning I want to go into more detail on these two aspects of the complaints process. Now, just very briefly, once the complaint is received, it goes to a panel. The chairman appoints a committee of your peers that will read and review the complaints as well as the written explanation by the doctor. I want to emphasize this. The investigation process takes into account the written explanation by the doctor and the expert reports. So we will come back and round back to this expert reports and the importance of the expert reports. If any or one of you encounter this unfortunate scenario, it is so important to have an expert that deals directly with the complaints in question. Those who might be more familiar with medical legal, we're talking about the Bolam Bolito, although not necessarily applicable to a disciplinary process, it is nonetheless important for the committee who might not be of that same specialty to be appraised of what your peers would have done, be it whether in support or whether be it improvements can be made, but it doesn't cross the threshold of professional misconduct. I will move to the next slide on the disciplinary process proper. All right, I think this is quite familiar to most. The trend that we have been seeing so far has been suspensions as the final outcomes. Obviously, this trend does not mean that it will always be, but I think the cases that we've seen in recent times have related to the practice management as well as the competence, gross negligence sort of cases tend to attract a suspension type sentence. What is important for the doctors to know, not so recently, but many still may not know, that historically, when we first started, only the doctors could appeal to the High Court, which is the final tribunal for the SMC disciplinary process. We have seen SMC lodge various appeals as well, whether be it in terms of the conviction or acquittal or the sentence that have been imposed. So that is an important point to note. Next slide deals with dental counsel. Why we are highlighting it is because for the SDC, the appeal process is not open to SDC. So in dental cases, we are talking about the complainant who is allowed to appeal. So that is one of the main differences. The rest, by and large, I won't bore you with the details, but by and large, it is very similar. I want to move on to the mediation. I think this is something I want to highlight to the doctors as well as the dentists and other health practitioners. If you look at the trend within civil cases, so civil cases distinct from professional misconduct allegations by the councils. In civil cases, we have a very strong push. Indeed, I cannot remember any civil medical negligence case that I've handled in recent years that have not gone for mediation. Yet when I look at the statistics in 2018, to be fair, I'm not sure about 2019, the numbers were very low for those which went into mediation. And as far as we could see from the reports, only 2 were successfully mediated and resolved through this process. I think the professional practice should, in my personal view, head towards this attempt of trying to have parties resolve the matter. I mean, I read an article in Lancet where they say there is no winner. There is no winner even if the doctor at the end of the day is acquitted in a professional case or is not found not to be liable by a court, because unfortunately the nature of medical cases do attract media attention, and no one, whether you win at the end or not, would want this to affect their reputation. So the benefits of mediation is, well, obviously it is faster, cheaper, you don't go through the whole trial process. Confidentiality, I think for most of you, would be the biggest attraction. And you have control over what happens. So for example, a lot of people, and indeed complainants, simply want some sort of acknowledgement, some sort of explanation, some sort of interaction with the doctors in an open, transparent fashion. And many a times, sometimes the patient simply wants a verbal apology, and it goes a long way. Now, this process is governed by confidentiality and privacy. So in the event the matter does not resolve, what happens in the 4 walls of the chambers or the mediation chambers cannot be used against the doctor. So I think that is something I want to bring up this morning for all your consideration, and I question why it is not used more frequently. MOH, in case those who are in bigger institutions, has a healthcare mediation unit. A lot of the times, the complaints of individual patients kind of fall through the cracks, or perhaps are not handled in the same way by a medical practitioner as an administrator would handle the situation. And it cannot be said enough that the healthcare practitioner who is captain of the ship, so to speak, for that particular patient, having an interaction with that patient to try to understand the complaints or the misgivings the patient would have, would go a long way towards avoiding even a complaint eventually being lodged. So I think that is something for clinics of all size and numbers should consider putting it as part of their protocol. So through the course of this conversation this morning, we are going to focus on matters that you can and should have as part of what I say are your SOPs. In listed companies and big private companies, they call it crisis management. I mean, that is a scary sounding word, but it can be patient management manual, where the clinics, or if you run several clinics, all have the same SOP and is channeled to the right individual, rather than it be dealt with in kind of a hodgepodge scenario. For those who own clinics, the manner in which you conduct yourself when a patient complains sometimes is a true test of that entity, the ethics of that entity. And similar to a law firm, unfortunately for lawyers as well, the numbers go up over time, and we get complaints across the board, and sometimes how we resolve it, engaging the patient or our client, does avoid a complaint being lodged. And that is the key to today's conversation. You do not even want to expose yourself to the whole SMC process for which you have no control over. The next that I alluded earlier is this concept of interim orders. We thought we should speak about it. I think that's the next slide. I thought we should speak about it because in recent cases, this is a tool that the SMC uses in order to, as you can see from the slide, to protect members of the public or to act in the interest of the public at large, as well as the medical practitioner. So it's a balance of making sure that the concern of the public about the continued practice of a certain practitioner who may be unfortunately facing some allegations yet to be determined, of course, is balanced with the interest of the medical practitioner who should not unfairly be restricted in his practice. Again, I must emphasize that allegations have no weight. They are merely allegations unless they are proven, and the whole process of an inquiry or a trial is proceeded with. So the interim order does not either way determine the guilt or innocence or liability or otherwise of any medical practitioner. I think that's important to note. In the IOC cases that I've done historically, it tends to be, and I would strongly suggest to make it amicable, because at the end of the day, the practitioner does not want some unexpected order being imposed to restrict his practice. And certainly that is not the intention of any interim orders committee. But if you hold your cards very close to your chest, sometimes, and the IOC can't read them, they might make orders that are unduly oppressive. Through no fault of theirs. So many cases, just to give you some examples, we will speak to the doctor. I act as prosecuting counsel on some occasions. We speak to the doctor's counsel, of course. We try to mark out what is fair in the sense of what areas of practice I would require to be restricted in order to do the protection component. And of course, the doctor or his counsel, his lawyers, will tell me what aspect of his practice which should not be restricted, because it would essentially put the doctor's practice under the water for months on end, which is not fair either. So many a times we draw a very good compromise in limiting or ensuring that the limit of the restriction is quite circumscribed and does not impact financially the ability to practice, as well as continuing patients who may require or want to be treated by this doctor. So I think that is very important. We don't want a situation where the restrictions do not in any shape or form protect the public, or in an extreme case, restrict the doctor to an extent that is oppressive. So this is the balance that one seeks to achieve during this IOC. At this point, I think we have spoken about the general landscape and the two parts of this landscape that is traversed, that I think should be highlighted. So far, I don't see any questions, so perhaps we should move on to the next topic, unless Alvin has some questions.
Well, yes, maybe, Melanie, thanks for sharing the overview of this entire landscape and process. You mentioned earlier about this expert report, and this was something, if in an unfortunate situation where a doctor is faced with a notice of inquiry and is plunged into this disciplinary process, what are some things that a doctor should look out for, and perhaps in the context of what you mentioned about an expert report as well?
Yes, this point came to mind because of there was an orthopedic surgeon's case which was unfortunate. And when I read the decision of the Court of 3 Judges, it came to my mind that if the expert report for the doctor, in favor of the doctor, had been obtained to try to flesh out some of the inadequacies in the counsel's or the prosecuting counsel's expert report, it might have helped resolve this issue at the disciplinary tribunal stage. And don't get me wrong, it's easy to say all this with 2020 hindsight, all right? I'm not here criticizing any party, but it really brings to bear why I say, if you are responding to an allegation, you are a specialist, for example, the orthopedic surgeon, you can and should, in fact, get a third eye on it, because you are facing the allegations. You are not the best person to be reviewing it, obviously, because you would not be in the best state. Getting a colleague to look at it and inform you that perhaps that report may not be sufficient or is deficient in certain aspects. And in this case, the framing of the issue done by that SMC expert was not done sufficiently well, and the Court of 3 Judges had questioned whether it even amounted to professional misconduct, means the act itself, and whether it breached the acceptable standards of professional misconduct was not even met. So I think this is something that any respondent doctor who finds yourself in an unfortunate situation should bear in mind. Be critical, critical in terms of making sure that the issues that are being answered in both sides' reports really meet the professional misconduct allegation at its head.
Thank you for that, Melanie. So a shout out to our participants. If you have any questions during the presentation, please feel free to ask. There is a little pop-up box called Q&A, and if any time there's a question that you have, you can write it into the pop-up box and we will address it at the appropriate segments. So next, I will hand over the time to Manping, who will be sharing a bit more about the specific cases in a disciplinary and a civil context. Manping, please.
Thank you. So today I'm going to talk about a little bit more about the cases that have gone on before the Singapore Medical Council and the Singapore Dental Council. So these are all in the disciplinary context. Later on, I will talk a little bit about cases that have gone on before the courts in civil medical negligence cases. So we see we've divided it into a few different categories, but these are of course not exhaustive. A complaint can be brought to the medical council on any aspect of the patient care, and even beyond that, things like overcharging, etc., have also been complaints that have come before the medical council. But I think the by and large, the bulk of the complaints we always see is in relation to the treatment itself, the things that's explained by the doctors or rather not explained by the doctors, and the actual care and operations that are being conducted. So let me go into a little bit of detail on some of these cases. For informed consent, I think you all probably know what it's all about. Many of you in your CME talks would probably know that this is a requirement of a basic fundamental requirement of patient care, that you have to explain to the patient all the necessary risks, complications, and give the patient sufficient information that they need in order to make an informed decision on whatever treatment it is that you are recommending. So there are some cases that have gone before the medical council. Some have succeeded in getting conviction, some have not. Primarily, if you look at this list here, we see Dr. J, Dr. L, and Dr. R were actually convicted of professional misconduct. Dr. L is, sorry, there's two Dr. Ls. Number two, the Dr. L is the one that Melanie has already discussed. There was actually a conviction. In fact, the doctor actually pleaded guilty to the charge of not getting informed consent. But eventually, it was set aside by the court of 3 judges because they felt that the risks that the doctor had explained were actually sufficient. They also took note that he actually gave the patient other options that were even more conservative than steroid injection. I mean, in this case, a steroid injection is not really considered that invasive, but even then they considered that he had offered the patient other types of treatment, such as bracing and giving just oral medication, and the patient had rejected it. So these are considerations that the court took into account to say that at the end of the day, the doctor did in fact give the various options available. He did talk about certain risks, not necessarily all the risks, and that was where Melanie brought in the idea of the expert report having to be sufficiently detailed to show what is so important about the risks that were not explained to the patient. If you cannot reach that threshold to say that it is so material, it will have some impact on the patient's ultimate decision whether to proceed or not, then it really will not reach the threshold of failing to get informed consent of the patient. And that was why for this case, the conviction was actually set aside by the court. And this is despite the fact that the doctor himself had, as I said, pleaded guilty in the first instance. For the other cases, the disciplinary tribunal had found the doctors to have failed to obtain informed consent, primarily because they don't just look at the consent form. I think it is quite accepted by now. I think you all know consent form itself is not conclusive. For example, in hospitals, the operations, you always sign a consent form, but that doesn't mean that the doctor had actually obtained informed consent. They will look into the question further as to whether the doctor actually discussed the risk. did he actually give all the available, well, all the relevant options, not all the available ones? And then in terms of risk, we will talk about the balancing of risk later on in the modified Montgomery test. I think you all may have heard of that. That came about in the case of Hitchcock that was before the courts in, I think, 2017. So there has been a slight change in the test of how do you evaluate whether this risk is material or not, such that you need to explain it to the patient. So we will talk about that in a while. But for the present moment, I think it's been quite clear in all the cases that you don't just look at consent form, you look and evaluate what the doctor actually explained. And you have to also look at what kind of patient it is that you're dealing with. If you have a more savvy, a more educated patient, perhaps they may have done some of their own research and you don't go into so much detail. On the other hand, a very savvy patient may also ask more questions and then demand more information. So at the end of the day, it is really a judgment call, a balancing act as to how much information you give. Okay, so that's for informed consent for now, but I'll go on to the other aspects more in a bit more detail. So clinical evaluation and patient care. These are just a few examples. Like I said, there's a whole variety of complaints that come before the medical council. The bulk of it has been dismissed, means really no issue at the end of the day. But there are a handful that have gone on to the disciplinary tribunal or disciplinary committee stage. And these are the ones that have eventually been found by the tribunal to have reached the stage of professional misconduct, and they were actually convicted. And in most of these cases, they were suspended, ranging from your minimum 3 months, 3 years. Most of them, they are somewhere in between 6 months, 12 months, kind of suspension. So for Dr. M's case, there was a patient who came and had diabetes, and the doctor simply gave medication and medical leave to this patient, but it was found to be insufficient, primarily because this is a patient that has a chronic condition, and you can't just treat him like any other patient who's perfectly healthy. So you need to go further and do certain investigations. And in this case, they found that he should have done a blood glucose test, he should have done further physical examination, and if necessary, if there were developments in this condition, the doctor should have referred him to a hospital. He didn't do so, and the patient was subsequently diagnosed with gangrene and had to go for 3 surgeries and was warded in hospital for a very long time. So they found that he had breached in failing to conduct further investigations and doing a proper assessment of the patient. Then we have the 2 cases of Dr. W is actually related to another case called Dr. Z. I think it was on our chart earlier. And this you all may have heard because this was one of the cases that's really widely reported in the papers. It was not just going before the medical council, it was also one of the cases where the coroner's inquiry investigated into it. And of course, eventually there was also a civil lawsuit. And the court actually said that this is really one of the most egregious cases ever to have come before the courts or the tribunals, because the doctor, who was actually a GP, did liposuction on the patient for aesthetic purposes, obviously, and he actually didn't have the necessary training for it. Notwithstanding that, he went to carry out liposuction and gave the patient a whole lot of propofol for the anesthetic effect. And even though he had an anesthetist, the anesthetist was the other doctor who was also prosecuted together. At the end of the day, both of them were found to be so negligent because they gave the patient so much propofol that they were unable to wake the patient up at the end of the surgery. And also, they then left the patient unattended, even though the patient had not yet awoken. And they didn't realize that he wasn't able to be roused from the anesthesia. And that was why the delay in then trying to do corrective treatment on the patient completely failed, because they were way too late. They didn't monitor the patient. So both doctors were actually found to be guilty of professional misconduct. Obviously, the surgeon, being the main attending doctor, got a heavier sentence. He was eventually struck off, whereas the anesthetist who was assisting him got 18-month suspension. And these were actually all enhanced sentences that was enhanced at the court stage. The tribunal below had actually given a suspension, but a lower suspension. But the court felt it was really very egregious and therefore enhanced the sentences. The Dr. Y, for the dentists who are out there, if you are in the audience, Dr. Y is a case of a dentist, and it is he had prescribed ibuprofen to the patient, even though there was an allergy specifically recorded in his notes that he was allergic to this kind of medication. So this is really a very, very basic error in that sense. Obviously, the important thing to all doctors and dentists, first thing is before you prescribe any medication to the patient, you need to check the case notes to see whether there's any allergy recorded. In fact, in most cases that I myself have come across, the doctors themselves will also ask the patient, do you know if you have any allergies? So that's just an added layer of precaution. And if you don't even carry out this kind of basic checks, then obviously at the end of the day, the DC found that it was gross neglect. And because allergies can come up to be very, very serious, you can have Stevens-Johnson syndrome, for example, which could potentially be fatal. The court, well, the DC felt that it was something that was so egregious and convicted the dentist here. Then there's something slightly different. This is also two dental cases that were dealt with side by side. One was a supervisor, and the other one was the conditional registrant that he was supposed to supervise. And at the end of the day, both were found guilty because the supervisor actually let the supervisee treat a high-risk patient, even though it was just a wisdom tooth extraction, probably something that dentists do day in, day out for your regular patients. But because this was a high-risk patient, he had palatal tetralogy, which is really a heart condition. And in fact, he had a pacemaker inserted. And this is quite a sad case because the patient was actually a 20-year-old boy. Well, we are supposed not even an adult yet. And eventually, he actually passed away, although it is not proven to be related to the wisdom tooth extraction or anything. But nobody knows what happened during the extraction, such that the next day, immediately after the extraction, he suddenly had some attack came on and he actually passed away. So it was quite a sad case. And unfortunately for these two doctors, they were the ones who had done the operation for the extraction. The supervisor had actually left the clinic, and even though he knew the patient was coming in and he had discussed, he had sort of run through what had to be done with the patient with the supervisor, telling the supervisor, okay, you need to do ABC. But because the supervisor left the clinic for that 2 hours when the patient came in, the supervisor was left on her own to carry out the wisdom tooth extraction. And this was found to be a serious omission enough such that both were found to be guilty of professional misconduct. So for supervisors, be careful, because it doesn't mean that it's sufficient just because you have sort of previewed the consultation together with the supervisee. It is also not enough that you review the case with the supervisee after the consultation. What it requires is that you are actually present, at the very least present in the clinic, if not in the same consultation room during the procedure. So it is quite a strict requirement. At the end of the day, probably in practice, it may be quite difficult to implement. So you need to make a judgment call as to what type of procedures and what type of patients are in the high-risk group, such that you need to be present to actually effectively have supervision over the registrant. Okay, Alvin, is there any questions at this stage, or shall I move on?
Maybe I can just jump in with a question.
Sure.
So, Manping, you were talking about informed consent earlier, and now we know that the internet contains so much information, and patients are increasingly sophisticated as well. So what happens is in a case where a patient comes to see a doctor, and the patient says that he has done all his research on the WebMD, knows all of the risks, and just wants the procedure to be carried out. What should a doctor consider or do in those kinds of situations?
Yes. I think this is quite common, that a lot of patients would have come and said they've done some research, whether it's WebMD or some other website. Obviously, the doctor cannot just go ahead and say, oh, you have done everything on your own, you have researched everything, and I don't have to tell you anything. Let's just sign the consent form and go ahead with the operation. I think most of you will know that is not the way to do it. But the question is, how much then do you, how much information do you then give the patient? I think it's still important for the doctor to then discuss with the patient, okay, what is it that you have found out, you know, and really correct, because there could be a lot of misinformation out there, especially if the website that the patient looks at it is not really an accredited website. You know, there's a lot of information floating out there in the internet. So you need to make sure that the patient knows what is the real, valid, and relevant information for that procedure. So it is still important for the doctor to run through the risks and complications, and make sure that this patient really understands what is it that he has heard, what is it that he has read. So I think if you have, like I said, if you have someone who is more savvy, perhaps you can discuss a little bit more. They may have questions that say, oh, what about this that I read online? What about this? And then to that extent, you do need to spend a little bit of time allaying their fears that, okay, maybe this type of treatment is really not evidence-based, is not really supported in Singapore, or something that's not offered in Singapore. Or for example, this risk is really so rare that it has never happened in 1 million cases that we have seen so far. You know, things like that. So some time still needs to be spent to, like I said, allay the patient's fears and talk about what is really relevant to the treatment itself.
Thanks for that.
Yes.
Maybe we can move to the next segment.
Okay. So for this second part, I want to talk a little bit more about the civil cases that have come on before the courts. You all would probably know this kind of claims, medical negligence claims, are where the patient goes to court and wants to claim compensation, or what we call damages, from either the doctor, the clinic, or the hospital. And this can again cover all the various aspects of a patient-doctor relationship. And broadly, we look at it as three aspects. One is the advice stage, one is the actual diagnosis, and one is the treatment or post-op care. So there are three very broad aspects that, and all three can in fact be encompassed within one claim by the patient. There are various tests that have been used by the courts to determine if there has been a breach of the doctor's duty of care to the patient. Probably you all would all know, I mean, this is a long-standing test called the Bolam test, which has then been modified to something called the Bolam-Bolito test. In fact, this Bolam-Bolito test has also been around for many, many years. In Singapore, it has been adopted in a very seminal case called Gunapati's case. So you may also have heard of that. So in short, the Bolam-Bolito or Gunapati's test is essentially a test that is based on what is the standard of a reasonable body of responsible doctors. Essentially, if you can find, if you have a reasonable, a responsible body of doctors or medical practitioners, whether it's doctors or dentists, who say that, well, this is the correct way to do things, you know, the doctor did this correctly, then by and large, it would say, the court would say there's been no breach. But but there is a qualifier, and that is the Boliter qualifier to the Boehm's test. And that is that whatever this body of doctors say, what their opinions and their practices that they uphold must be a logical, defensible body of opinion. So the courts will still look at whether this this opinion has been reasonably obtained, meaning did this body of doctors consider all the relevant medical information in relation to this treatment before they come to the conclusion that, okay, this is the way to carry out this treatment. So there's a little bit of analysis on the correctness, in that sense, of the opinions of this body of doctors. So that is how the Boliter test has been qualified, so that we don't have cases, doctors basically running amok and doing strange things because you can find some strange group of doctors practicing very far out kind of treatments. That is not how it's going to be adopted, because I suppose in many cases you will have doctors who are more sort of pushing ahead of the rest of the acceptable body of treatments, and they want to try new and novel things. So you will always be able to find a body of doctors who will try out all these new things, regardless of whether they have actually been found to be evidence-based, regardless of whether they have been found to be acceptable practices. So just because we have this body of doctors who do that doesn't mean that it satisfies Boehm's test. And you still need to see whether that opinion held by this body of doctors is really a valid opinion. So that is for diagnosis, in terms of diagnosis of a condition and the treatment portion. Then for informed consent, there is a slightly different test that is called the, in the current test that we have now is the modified Montgomery test. In the past, it's still used to be Boehm's test and all that, but it has been changed over the years, and the courts have felt that it is more important to look at not just the patient's, not just the doctor's perspective, but also the patient's perspective. Because at the end of the day, informed consent is really whether the patient has sufficient information to make an informed decision, whether he knows what exactly he is going for when he has consented to that surgery or procedure. So they have switched to something more patient-centric. And this is where I will go on to talk about the case of Hitchcock. This is where the modified Montgomery test was formulated. Let me just go into the steps. Yeah. So the court formulated a 3-stage test. So when you talk about what information you give to the patient, the first stage is you look at the information that's relevant and material to a reasonable patient in that patient's, a reasonable person in that patient's condition. So an objective patient, what would he want to know? What would he like to know in terms of the various options, various risks? And there would be, again, a balance drawn between too little and too much. Like I said just now, eventually it is a judgment call, because you do need to balance between risk, too much information such that it becomes an information dump, and then too little such that the patient is just basically blindly consenting to the information. And how the courts have sort of measured it is, even if risks that are likely to transpire, if you have a very high likelihood of the risk occurring, but the outcome is a very, say, not a very serious kind of consequence, but because it is so likely to occur, you do have to disclose this risk. On the other hand, if it is a risk that is a very, very low risk, such as risk of death or risk of paralysis, but the consequence is such a serious thing, it is fatality, it is being bedridden and handicapped in a wheelchair for life, then you still need to disclose it to the patient. And by and large, we do see, even in the hospital consent forms, for example, you see death is always one of the risks that's listed, because it is, even though it's very probably 0.01%, but it is very, very serious consequence. So at the two extremes, the court can say, look, okay, so for this kind of two types of risk, you should be disclosing it. But when it comes to the middle, where there's a spectrum of not so likely or not so serious, then it becomes a very considered opinion as to, at the end of the day, do you think this patient would want to know? And for that, you do want to look at the characteristics of the patient. If the patient is hypochondriac and wants to know every single thing, then you do need to be sensitive to this kind of characteristics and give a little bit more information. On the other hand, if it's perhaps a patient who is easygoing, he says, look, I just want to get over with this, be cured of this, just tell me main things, and then, you know, I'll go ahead. And then you calibrate according to the type of patient you have. But bear in mind that if things that are so fundamental, you still should be disclosing them. Then the second stage we look at is really whether he's in possession of the information. Obviously, if he's not in possession, then it is not a case of him breaching informed consent. But the question is, did he then do the relevant tests and investigations to get to be in that position to advise you properly? So at the end of the day, that may be a question of negligent diagnosis, negligent assessment, but not really informed consent. The third one is stage 3 is really, is he justified if he withholds certain information? There are certain recognized categories like waiver, therapeutic privilege, or emergency situation. I think you all would know this kind. So I'll move on. So that's for informed consent. The second case is slightly different. It is about a test that was done by a laboratory. And I don't think it will probably be so relevant to most of you. But at the end of the day, the takeaway from this is really that statistics is really just statistics at the end of the day. And because it was about whether a patient who had malignant melanoma, if the test had been known, had been done and known earlier, would it have really offered him a cure? Because he would have wanted to go for a surgery to get rid of this melanoma, and would he have been cured? So there's a lot of balancing of statistics. At the end of the day, the court said, I'm not going to decide this on statistics, because here, at the end of the day, here it was found that, look, the test, if it had been done, the patient would for sure have gone for the biopsy at the surgery to take it out, and it was shown that it would have cured him of this condition. So it was the patient succeeded on that basis. So there was, although the court analyzed the question of how many percentage of risk of death, and how long you would have lived in 10 years time and all that, but at the end of the day, no real no finding needed to be made on this point. This one is third case is also, probably you all may have read it in the papers. It is quite significant because it went to the court of 3 judges, and it was a patient who sued the hospital together with the A&E doctors and a specialist who had seen her. And at the end of the day, the doctors were all found to be not liable because they are all just part of a system. So the court had regard to the team-based system in the hospital and said that, look, each person is treating one specific aspect, especially an A&E situation where there's urgency, life-threatening conditions. So you may not have the time or the luxury of going back into all the clinical history. So they were found to be not liable, whereas the hospital, at the end of the day, was found liable for not putting in place the relevant systems to make sure there were proper follow-ups at each stage. So that is how the courts will view team-based kind of work. So that may be relevant to those of you who work in the team-based system in the hospitals. So I think that is the end of it that we have time for. Alvin, is there anything arising?
Maybe we can do some of the wrap-up points, and then we will circle back to any final questions that we have. So Melanie, I think you had some takeaway points for all of us from this session.
Yes, last 5 minutes, I think that's what people came to hear. That's the last 5 minutes of what we're going to say. What do I do? After being educated on all these dangerous pitfalls, what can I do? Look, simply put, don't information dump, adopt a practice that suits that particular patient. So what does this all mean? In real terms, I've advised many clinics and organizations to have some sort of consent checklist. All right, you call it whatever you want. Why? Because showing any tribunal or any court that you have applied your mind to it, not just a random consultation where you state certain risks that pops up in your mind. So I think any organization should have a consent checklist, especially many of you are specialists, or for certain dental procedure like crowning, etc., have a list that can even be passed to the patient. I've seen clinics who have the list passed to the patient. They can bring it back, read it, all right? And the next consultation, certain questions can be asked from the patient. All of it is recorded. So any queries, concerns of the patient, any sort of lifestyle impediments that the patient may be concerned about because of the type of patient, you can throw it back to the patient. Ask the patient, is there any part, any area that you may be concerned about? And this leads us nicely into the final consent form. So I would do it in this sort of three-part process. And we have said it many times, consent is a process. It is not about having the patient sign a consent form as they're being wheeled into the OT. I don't want to be dramatic, but that actually happened before. That's why I'm raising the example. Thankfully, not in recent times. So this is the balancing act which the doctors have to balance at this stage. I want to raise the point about doctors asking me, what about the nurses? Are they able to assist with that? Again, I understand the practice is difficult and long hours. I would say the checklist or whatever form you have, all right, you can have the nurse go through that process. But what the nurses explain doesn't count in that sense. But I think it's good to have the nurses have it recorded that they went through, and any questions that is asked, certainly the nurses and the patients can then float it up to the doctors. I think there's been some questions or feedback about legal protocols in place in every clinic. I agree. The question then is the sufficiency of the protocols. Have they been adjusted to take into account the sort of changes? And I would say informed consent is a marked change in the law. Insofar as the duty that is being placed on the practitioner is no longer judged from the body of practitioners, but more from the patient perspective. The next point that we have to make about takeaways for proper clinical evaluation. And this is two main, next slide please. Two main aspects I want to highlight. I think Manping alluded to this about allergies. Unfortunately, it has happened before and perhaps one too many times. This is a systemic problem, means the patient actually filled up the form, but when it was passed, the files from the patient reception into the doctor's room or the procedure room, the sticker where you have the allergy was unfortunately missed. So this is a systemic problem which has to be resolved, of course, within the entity itself. The other one that comes to mind is locum or duty doctors. So in several GP setting clinics, unlike the old days where you have the same guy throughout the working hours, there would be doctors that take certain shifts. And unfortunately, in one case that I did, it was the failure to properly conduct a clinical examination on a boy. And it was unfortunate that he had appendicitis and it erupted and he had to send to a hospital on an emergency basis. So what is the key here? I think as the head of the clinic or any entity, the education that must be given, be it locums or duty doctor, the key is the notes must be sufficient, all right, to be able to allow another doctor to take over the management of the case. This harks back to some of the principles that may be familiar to you on informed consent. But in the case that I did, that's what the tribunal said. When they looked at the notes of this doctor, it clearly was deficient even for himself, because he was the one who actually saw this same boy over a few consultations, but had improperly conducted the clinical examination and therefore missed the signs of appendicitis and didn't refer earlier. The other third point about clinical evaluation is, please do not forget post-op. Please. We have seen again too many cases where once the procedure or surgery has been completed, instructions indeed were given by the doctor, especially now we have international patients who come in just for the procedure and then they go back home. Instructions that were given to the clinic to follow up, at least to call, to check whether there's any pain, bleeding, etc., wound healing process. All those have to be put again in the whole protocol that you have. Why do I harp about protocol? Manping mentioned earlier about the liability of a doctor versus the entity. You will see in many civil cases, fortunately for the doctors, they were not found liable, but the hospital was found liable. Why is that? Because the hospital has processes, or should have had processes, and they failed to follow that process. And that is why the entity is liable versus the individual doctor. All right, so that is an important point to note. You put in your processes, even though you are captain of the ship, hopefully the well-meaning and detailed processes will hold you in good stead if the unfortunate day comes that you have to be scrutinized on your practice. I think Dr. Key is the only one that has been asking, so I should attempt to answer his questions. He talked about the temperament of doctors and whether legal training can be actually done. Well, it has to be done. I think at this point in our day and age, legal training, medical legal issues, the doctors have to appraise themselves of them. That's what the CMEs are. And there is no worse experience for a doctor, indeed any professional, than to be facing disciplinary action or a lawsuit for your professional care, because I think we're all here to do some good and certainly not to harm anyone deliberately or maliciously. Medical records also are so important. I've done several cases where part of the series of charges that are framed against a doctor, one of them talks about inadequate medical records. All right, and I mentioned earlier, continuity of care. We should not be doing this for the sake of preventing or succeeding against allegations. We should be doing it because it is part and parcel and important for your proper care and continued care of a patient. In the same way that lawyers are taken to task if we do not or are accused of not following instructions or taking the right instructions, and we go down a path that was not allowed or agreed to by our clients, then this is something that will help us or shield us. The notes that we took, the discussions that we had, the options that we presented, because there is many a times no one clear road in our professional judgment. So final point, if one talks about why you would have a case which succeeded and a case which didn't, we are really talking about the thought process that the doctor undertook, which can be recorded in the medical record. So I will leave you with that thought on the medical records and the importance of the medical records, which will shield you in any or hopefully most allegations where you are accused of not having considered the important points in the treatment or the care pre or post-op of a patient. So time is running, so I leave that thought with you. Thank you for attending this webinar.
Hi, so thank you everybody for your time, especially our panelists from Wong Partnership. Thank you very much for using your mornings to educate us on more, on more these legal terms that I'm sure not a lot of people actually know about. So thank you very much, Manping, Melanie, and Alvin, for your time in the morning, and also thank you for everyone in the attendees for joining us this morning for what is another very educational webinar. So hopefully everyone stays safe on this Saturday, and thanks for joining us. Everybody have a good day, and take care.
Thank you. Goodbye.
Thank you. Bye-bye.